pursuant to Section 1083 of the Standing Orders, the committee is undertaking consideration of the 2026 spring reports of the Auditor General of Canada. Sent to the committee on March 23rd, Monday, March 23rd, 2026. Chair? Yes? Mr. Deltel. Thank you, Chair. So once again, I would like to request a clarification. I know that recently we examined the case of the scandal in Laval where they have to pay $1 million to the Canada Revenue Agency, and we would like the Minister of Revenue of Canada come and testify here before the committee. We made a request formally 3 weeks ago. I would like to know whether Minister Champagne has given any response and if he will appear before us. Thus far, we do not yet have a date for the Minister of Finance, but it's a good question for the question period. When he's there, we'll continue to make the request to have a date for him to appear here before summer. Thank you. Thank you very much.
Get going from the Office of the Auditor General. Karen Hogan, nice to see you back again, who's the Auditor General of Canada. Gabrielle Lombardi, nice to see you back as well. And Aaron Jelinek, nice to see you as well. From the Department of Citizenship and Immigration, Ted Gallivan, nice to see you, who is the Deputy Minister. Alexis Graham, Acting Assistant Deputy Minister, Economic Programs, nice to see you. And Tara Lang, Director General, Admissibility. And I'm sure I'm going to figure out how to pronounce that in a second. And from the Canada Border Services Agency, Aaron McCrory, nice to see you as well. Vice President, Intelligence and Enforcement. I believe there are two opening statements. Ms. Hogan, you can kick us off for about 5 minutes, please.
Merci. Bonjour, Monsieur le Président. Je vous remercie de nous donner.
Thank you, Chair. Thank you for giving us the opportunity to testify here before the committee to discuss our report on reforms of the foreign student program, which was presented last March. I would like to recognize that this hearing is taking place on the traditional unceded territory of the Algonquin Anishinaabe people. In the framework of this study, we examined the implementation of the program reforms for foreign students by Immigration, Refugee and Citizenship Canada, and this reform aimed to manage the growth and strengthen the controls for integrity. Overall, we concluded that although the department reduced the number of new study permits delivered, it had not responded to the expectations in other key areas. In 2024, the department delivered a bit less than 150,000 new permits, which was lower than the forecasts that were more than 350,000. Some provinces, in particular those that have lower populations, were affected to a disproportionate degree. For example, it was expected that Newfoundland, Labrador, and Saskatchewan would both have an increase of 10% in the number of new study permits approved compared to the previous year. However, they both had a decrease of at least 59%.
Although the department introduced a new tool to verify acceptance letters and had processes to identify potential fraud and student non-compliance, it did not effectively investigate or follow up when risks were flagged. For example, in 2023 and 2024, designated learning institutions identified over 153,000 potential cases of non-compliance with study permits, but the department investigated only about 4,000 of them. Most cases could not be closed because students did not respond to the department's requests for more information. Further, the department's fraud detection activities identified 800 cases of fraud after permits were approved. No follow-up occurred on these cases. In most instances, individuals went on to apply for other immigration permits while in Canada. More than half of those applications have since been approved. Our audit also identified an opportunity for better collaboration with the Canada Border Services Agency. We found that the Immigration Department did not collaborate with the agency to identify whether students with expired permits had left Canada. Using the Immigration Department's available data, we worked with the Canada Border Services Agency and found that only about 40% of the 39,500 students required to leave in 2020-24 had in fact left the country. Ultimately, the department needs to act on the information it already has to address integrity concerns in the program, including collaborating with the Canada Border Services Agency. This is equally important when students are in Canada and applying for additional permits. Monsieur le Président, je termine ainsi ma déclaration.
Chair, this concludes my opening remarks, and we will be pleased to answer any questions from the committee members. Thank you.
Merci beaucoup.
Thank you very much.
Opening statement for about 5 minutes. Thank you.
To provide greater controls in the program.
A number of areas of improvement, both in terms of the decrease in the number of students, which was the strategic objective. Secondly, the implementation of a letter of verification process with educational institutions. And finally, the cancellation of the student direct stream. That program no longer exists. Ce que je dirais, Monsieur le Président, c'est que nous avons un plan d'action.
As I was saying, Chair, we have a plan of action, and it's important for me that all plans of action be completed in 2026 and include action at the appropriate time. And secondly, we have undertaken to follow up on 100% of those files where there's a possibility of fraud. And furthermore, when there is indeed a gap or a nonconformity with the regulations, we take 100% responsibility for those cases. And finally, we have taken the responsibility to better manage the end of visas. When a visa expires, we undertake a responsibility to do a follow-up. Thank you, Chair. And I will be prepared with my team to answer questions. Thank you very much.
Suivant consists of 3 members, 6 minutes each. Mr. Redikoff, welcome. You'll kick us off for 6 minutes, please.
Thank you, and thank you to the witnesses for being here today. Auditor, thank you for that report. It was a great report. And in there, you had mentioned 51 cases of letter of acceptance fraud that you had looked into that were flagged, but the officers didn't follow procedures in 14 of those cases. Is it fair to say that IRCC systems can detect fraud, but then not follow through and still let it pass?
I think we've found many instances where the Immigration Department has information in their possession that they're not acting on, and their systems identified fraud or even flagged potential noncompliance with study permits. But it is that follow-through that is something that is lacking in many of the cases that we looked at.
Right. So in 12 of these flag cases, officers refused the applications for other reasons, but didn't actually resolve the fraud question. It was what you pointed out in the report. Mr. Gallivan, does that mean that your department failed to make a misrepresentation finding, failed to trigger a 5-year ban, and failed to alert the next officer who might review that specific file in another application scenario?
Thank you for the question, Mr. Chair. What I'd say is the potential certainly exists. Without knowing the facts of the case, you can't say for sure, but I think the concern the OIG flagged is without doing the homework and without documenting the file, that could have been the case.
So, Ms. Hogan, that would be an unacceptable situation where that wasn't flagged, and that's what you pointed out in the report, correct?
Absolutely, because those steps were meant to ensure that something be done if the person was found to have not followed the rules, right? Putting a flag so that you consider that during the next immigration status, or placing a ban. There are lots of tools in the toolkit at the Immigration Department, but if you don't take it to the end of the investigation, you can't use one of those tools.
So the study permit is one stream where there were problems with fraud. Did you have a chance to look at other streams to check for fraud as well?
No, this audit was focused solely on the international student program. So we did look at the student direct stream that had some concerns because certain countries that were in that stream were flagged as high risk, as potentially using fraudulent documentation, yet they were in the student direct stream, which would, by its nature, was meant to fast track and be a bit of a light touch. But it would have all been linked to international student, whether it be in one instance or another, but it was to the international student program.
So you also also investigated 800 cases where fraud was suspected, and actually IRCC chose to not investigate any of those. You mentioned that one. So as an auditor, would you be concerned that this pattern of not investigating fraud would be present in other immigration streams as well?
I mean, that's really hard to say. It would matter on whether the individuals who were carrying out the procedures here are the same individuals, what are the policies and procedures, what kind of oversight was exercised. I think it would be wrong for me to extrapolate that because in the international student we saw, the fact that there was information not being acted on, that would be extrapolatable to the rest of the department.
Globe and Mail had a story recently that showed that IRCC instructed its frontline officers to allow asylum claimants in the country, even if they suspected the client was not being truthful. It was a story that was a couple weeks ago. Does this type of behavior concern you, given what you found in the student program?
I don't know the article that you're referring to, and I think this is where I would expect that rigor be applied where rigor is meant to be applied. We saw that the Immigration Department has risk units that do a really good job of analyzing risk by country and by region, but then we saw inconsistencies with those risk assessments or the follow-through on information. And the department should care about the rigor of the immigration process, not just at the intake of an application, but while an individual is in Canada, and then when they should comply with the permit and leave. And we found that they really do need to do a better job at managing those risks throughout the rest of the process, not just the application stream.
So, Mr. Galvin, your department response to this, for this particular issue, said that you would add alerts to the file where fraud has been discovered. So, will this capture concerns raised at the very front end, like in the example I just mentioned about that was found in the article? So if an agent doubts the original story, will that actually be noted in the file?
The short answer is yes. The indicator's there for a reason, and IRCC will, through specialized compliance units, enhanced training, more clear direction, ensure that those are populated. And then to the OAG's point, more importantly, make sure there's follow-up action on those indicators.
So you'll be revising the instructions given to the frontline officers to reflect that then?
Yes.
Okay. Given that IRCC later removed the express entry job offer points specifically to reduce illegal buying and selling of LMIAs, are you concerned, Auditor, that the same pattern you found in the student stream, which was risks identified but weak follow-through, may also exist in work permit and permanent resident streams?
Again, difficult for me to extrapolate, but what I can tell you is we saw that extensions of study permits or applications for other types of permits were done with, and I'll call it a light touch, because there was an assumption of rigor the first time through, and what we saw was that wasn't always the case. So there is a concern there that now that risks have been identified, that the Immigration Department looks at how they treat individuals who perhaps made it through under false pretenses or with fraudulent documentation, to make sure that you don't apply the typical light touch on an extension, that you add rigor when rigor is needed. We have flagged all these cases to them, and I think it's up to them to handle the cases we've identified, but then to also to see if there's others within the student stream or other
Mr. Gallivan, have you found evidence of fraud in your first few weeks as a deputy minister?
There certainly was a practice of people falsely claiming to be students only to claim asylum. That's the kind of fraud that affected the student direct stream, and that's one of the key drivers to discontinue it. I think the concern now is what do we do with the people who came in while the program was in place, and the commitment we've taken is to follow through on all of those cases.
Thank you. That is your time. Now over to Mr. McKinnon. You have the floor for 6 minutes, please.
Thank you, Chair. We certainly welcome the Auditor General's report. Thank you. It's very favorable. It certainly indicates that the intents of the program has been largely met, and certainly strengthening the integrity of the system is a top priority. One of the things I believe I heard from Mr. Galvin's testimony is a difference in opinion relating to the amount of fraud cases that have been investigated. I'm wondering if there's a difference between how the Auditor General categorizes these as well as and whether IRGC categorizes them differently. So if you'd each like to respond to that, I'd appreciate it.
I don't think there's a difference of opinion. The Auditor General is correct. For example, the top line number of 150,000 is correct as potential fraud. IRCC at the time hadn't done the homework to distill that to the amounts of actual fraud. And so the Auditor General was 100% correct. There's a potential of 153,000 cases. We've subsequently done the homework and brought the number down significantly. We now believe that 22% of those cases are the potential fraud cases. We have more work to do to determine who within that reduced population have actually left the country, and that's something that we need to do more systematically going forward. But from my perspective, there's no daylight between the OEG's findings and ours. Had we documented and done the work that we've now done at the time, she would have had a different number, I believe.
So I'll agree with the Deputy Minister. I don't believe there's a difference of opinion in what we're saying. There are two buckets that we're talking about around this table, the 153,000 students who were flagged as potentially not complying with the requirements of their permit. There was only 4,000 investigated, so we didn't look into the 150 some odd other thousand. Out of those 4,000, more than about half were closed without going far enough. The student stopped communicating and the file was then closed. That is not determining whether or not the student is following the permits. So there's no disagreement on that, and I can't speak to the work that the department's done since our audit. The 800 cases of fraud were identified by the department themselves. Our concern is they did not consider any action on those 800 files when action should have been taken, and we highlighted in our report where all of those files are now. The majority have applied for other immigration status and about half have already received it. And it's that kind of thing that I hope the controls, better controls, will help prevent or make sure that those individuals really should have received another status. So there is no disagreement between the Deputy Minister and I on fraud at all.
So it sounds like the investigation of potential fraud has been very, very adequately and satisfactorily addressed. Do you believe?
From my perspective, once we implement the action plans that we have with the OEG and before this committee, Mr. Chair, I think they will be, but right now we're not there yet. And so there were a number of improvements. I think if you take a step back, there was a 4-year plan. Bring the numbers under control, increase controls, the student direct program being abused for asylum seeking, like those top line things were done and have happened. The OEG came in 2025 and saw that we weren't done that 4-year voyage. And so I think a number of actions that IRCC has underway and that we've committed to by the end of this calendar year will be necessary before your statement would be true.
If I could add, Mr. Chair, what I would add is there were hundreds of thousands of students that came through the student direct stream. And I would expect that the department will now look at the rigor they apply to any of those students when they apply for any other immigration status, because the rigor wasn't there in the first place. So you have the chance now to put a control at the second application.
Well, that brings to a more general question, Mr. Galvin. What is your department's response to the feedback shared by the Auditor General, and what steps will your department be taking going forward to address these concerns?
I think the most important message is all indicators need to be followed through. And so these very large numbers that we're talking about, 150,000 others, Mr. Chair, I think the Auditor General Canadians would just expect to see that IRCC goes through those files and comes to a determination. It's not good enough to say most of them have an innocent explanation. We have to do the homework. And so we've already started to set up teams. We have issued procedures. In fact, those field directions asked for are committed to by September 2026 in our management action plan to kind of begin to do that. And once we do it, we do get to a smaller number of people who applied for a visa under false pretexts. Then we need to follow through. We need to follow through in terms of a flag in the system. We need to follow through in terms of any renewal. With your colleagues earlier this week, we talked about the 5-year ban. But if somebody makes a if somebody doesn't leave the country when they ought to, they could be subject to a 5-year prohibition from reentry. And so we need to manage the immigration system with greater control so that the legitimate travelers and legitimate students, which the vast majority are, can come to this country and study, and that those who are trying to abuse the system suffer consequences and are disincentivized from doing it in the first place.
I guess I've got a few seconds left. I'm kind of interested in the numbers. So the numbers have substantially fallen in terms of approvals. But I understand the applications have substantially followed as well, and fallen as well. And I understand that the educational institutions have not been recruiting as vigorously. Is there any comment on that? Any explanation for that?
There certainly has been a chill, so the perception might have been greater than the reality. There is an issue, when we have time we can come back to, around the provincial allocation and unused spots. So right now there are unused spots in terms of the seats allocated to the province. But I would say internationally there was a message that Canada was being a little bit more rigorous, and I think it's a question of recalibrating that, because Canada benefits from high-impact, legitimate students. They're an asset to the country, and so we have to make sure that those students do continue to apply and come to Canada.
Thank you very much. Suivant, c'est M. Lemire, s'il vous plaît, pour 6 minutes.
Next will be Mr. Lemire. You have 6 minutes, please. Thank you, Chair. Thank you once again to the Auditor General for your work and for clarifying this issue for us. Mr. Gallivan, there's an aspect to consider which is perhaps even a greater problem. The Auditor General wrote that the department doesn't know whether the students were leaving Canada after expiry of their permits. So the Auditor General worked with your colleagues from the Canada Border Services Agency to draw up a list. And here we focus on one program, that of students, but it could be the case in many other programs. Do you have the numbers for all programs, and do you know how many people whose permit has expired who left Canada? And you have the numbers right now, and can you table them before the committee? No, we do not have exact numbers, and that's a problem. We have samples, we have projects, we have a broader picture, but we do not systematically manage the departure of visa holders. So for us, it's both the student programs, that's our first phase, in which we're going to put together or build something in the system and procedures. We're going to create a management framework to properly manage departures, and we intend to apply this for other visa programs as well. It's not all 80, but our team confirms that in May this year, we will for the first time have an indicator of presence in Canada. So I'm giving this as an example because we haven't really thought about it previously in the department to manage departures, but we are making a commitment to do so. So, according to the figures by the Auditor General, there are 23,500 people missing, and we don't know where the students are, whether they've left the country, but we ought to get some news in the near future on that. It would be interesting, perhaps, Chair, to be able to have another meeting to follow up on that. And then, in that regard, in connection with the question raised by my colleague MP McKinnon, we're talking about approval rates decreasing, what could be related to a decrease in the requests from universities. There may be a connection with more stricter measures in those applications, or are there certain relations with some countries which have simply become cooler and there are fewer applications from certain countries if we look at the statistics? I'll turn to my colleague for a more technical answer in a moment, but it's true that there are financial requirements there, and also we have cancelled the direct student stream, and there's also the climate. I don't know if you want to add anything. Yes, I could. I'm going to speak English if that's all right with you.
Excuse. Je vais dire que probablement oui, il y a exactement cette.
Yes, I would like to say that there has been a cooling.
I think it's important to sort of note that approval rates are primarily a function of recruitment practices of provinces and designated learning institutions. So IRCC can't approve an application that doesn't meet the requirements of the program. And those requirements did change, as we've all recognized. So there has been sort of this transition period from a more facilitative approach to a more controlled and disciplined way of managing the program based on allocations and lower numbers. And I think that has just created some need for these institutions to kind of look at student recruitment differently. And so we are kind of seeing those approval numbers being a little bit less, but we do anticipate this to rebound in the future as well.
Ben, en fait, les chiffres de la vérificatrice générale.
Well, actually, the numbers, we have the students coming from India through the direct student stream that came in 2018 and end in 2024. I see a direct tie with the decrease in applications. Also, the Auditor General indicated that you noted risks to integrity in 2022 and that no concrete action was necessarily taken following that. And today, students are still on the territory. Those people will renew their study permits or request or apply for permanent residency. What measures have you brought in to rectify this situation, particularly now 94 to 95% of applications are being accepted, even if, according to the Auditor General's data, 12% of the demands have ineligible indicators. In many of those cases of ineligibility, it comes from the direct stream. I believe that the plan of attack is to consider those who entered during the direct student program with higher risks. So, as mentioned by the OAG, if those matters of renewal, if there's a procedure, and we made a commitment to create a procedure, a more strict procedure to deal with the lack of scrutiny in the first level and make sure that it's properly verified and treat it as a certain population in which we have different risk assessment than from the population that followed the normal process. In addition, 541 fraudulent applications received either permanent residency or an extension of their study permit when they applied for asylum. How is it that even having committed fraud, those people obtained what they applied for? Is there a problem there that we ought to give priority to attacking? Perhaps I could start with I'll turn to my colleague in a moment, but I think we're touching on the jurisdiction of my colleagues, Manon and the Immigration and Refugee Board. I don't want to step on the toes of my colleague, but making decisions involves a number of indicators, and our role when somebody is subject to a decision from citizenship for permanent residency, we have a role to represent that, but there is a certain independent entity that takes all the factors into consideration and makes the decisions that they think are appropriate. I don't know if you'd like to add something.
Mr. Chair, when we're considering cases and when they're referred to the IRB, there are a number of reasons why we might want to intervene. Misrepresentation might be one of them, criminality, but officers have that discretion. So somebody who overstayed a visa one time, it's hard to say if that officer might decide that on the scale or balance of probabilities that this might be worth an intervention to the IRB to kind of interfere in an asylum claim.
Et voilà, merci beaucoup.
Merci.
Thank you very much.
5 members various times. Monsieur Dettel, vous allez commencer. 5 minutes, s'il vous plaît.
Mr. Dettel, 5 minutes. Thank you very much. Honorable colleagues, ladies and gentlemen, welcome to our committee and to the Canadian Parliament. I would like to start the question period briefly regarding what we're talking about. We're not talking about paperwork or piles of just anything. We're talking about human lives. When we talk about immigration, they're men and women who dream of living here in Canada. And I have to admit that with a certain dignity, there's a conflict of interest. My parents arrived on August 22nd, 1958, and they got off the boat at the dock in Quebec City. And when we talk about 150,000 potential frauds, it's a huge number, and it's quite a headline, and we can imagine how people might react. And above all, these are people who, in most cases, acted in good faith and chose to come here, and they expect the country that welcomes them will be able to live up to its exceptional reputation that our country has around the world. So my question, Ms. Hogan, when you discovered that 150,000 people who, as soon as you published your report, that they were going to become suspicious, that they would become targets, how did you respond to that? And do you consider that Canada did a good job in welcoming those people who, I am sure, would never have come here with the idea of doing fraud? And I don't think they were, we have to live up to the responsibility and reputation of our country. I would like to acknowledge that most of the students who come here through the program are true students. They're really here to study, to grow, to decide if they want to remain in Canada or return to their country of origin. In the case of the 153,000 people, these are cases in which the institution in question, the education institution, identified that perhaps the person is not studying full-time, or so perhaps the person is not fulfilling the criteria and requirements of their permit. They are lucky, they ought to give them a chance to show that they are studying, but not if they don't communicate with them, it's not acceptable. But if I come down to the 800 cases where the documents were fraudulent or where the person made imprecise representations, I think that has to be taken into account, and it shows the integrity of the individuals involved. So each case is different. From your viewpoint, is there a network of people who are organized to defraud the system, or are they cases which just accidentally come up without any connection between them? It's not easy to answer that. In the case of the 800 cases in which the documents were fraudulent, it was very clear that there were some 700 of them that indicated an institution that does not exist. So it's clear that there is an aspect that has to be investigated more rigorously, and the department ought to take those steps in those 800 cases. Do you have anything to say about this, sir? Mr. Gallivan? Yes, from the same viewpoint. That's why I talked about getting into contact with them. Earlier this week, I talked about education, first of all, explaining the rules of the game right from the start. When we talk about the end of a visa, or expiry of a visa, it's to remind people about what the rules are. So I think that the approach of our agency is to truly aim towards education, advocate clear communication, sure, with a certain threat. And I turn to my colleague at the end for a small number of cases. But you asked a direct question, are there networks? A small percentage, yes. There's organized crime, which will encourage members to work their way through 5, 10, 15 per year. It's not the majority. Mr. Macquarie, you work for the border services, right? So I look at this from a distance and I say, okay, of course you have the educational institutions or universities, and then you have immigration, citizenship and immigration, and then you have the border services. Is it possible that they're working in silos? Thank you, Chair, for the question.
In the immigration system, along with the Immigration Refugee Board. And in fact, in my experience, we actually work very closely together with IRCC, for example. And so
the results are not there. Even if you work together very well, the result is not there.
I give you the example of about 2023, when we'd identified an individual who had been providing students with fraudulent letters, and we worked with the IRCC to work through the students that were affected by that, some of whom were genuine students and that we allowed them to stay in the country, and others who weren't, that we removed from the country. And that was a very collaborative effort between IRCC and the CBSA.
Et voilà. Merci beaucoup, Mr. Deltel. Up next, we have Mr. Osborne, please. Minutes. And you're passing it on to Mr.
Yeah, to
Mr. Danko.
Yeah.
Welcome, and thank you for joining us today.
I will go third.
All right, very good then. So, Mr. Danko, just so you know, you have 5 minutes, and if you get your last question in within that 5 minutes, I do allow the witnesses to respond over your time. But if you interrupt them, your time ends. Their time ends. So, you've got 5 minutes.
Merci, Monsieur le Président.
Thank you, Chair.
Represent a riding with 3 post-secondary institutions, McMaster University, Mohawk College, and Redeemer University. So this is an issue that is very top of mind locally. And Mr. Deltel, I think, started on an important point that a lot of the international students that we're bringing in my opinion, were very much exploited. And they end up here thinking that they're going to get this great Canadian education, this pathway to citizenship, and a job and a life in Canada. And they end up in very substandard housing, in crowded conditions. They end up in a strip mall, in a poor education system, and just not receiving what they were promised. And my experience is largely in Ontario, where the provincial government basically created this system, this scheme, where the post-secondary institutions were almost forced to rely on international students as a source of revenue. And, the extreme example of that is Conestoga College, which at one point had 30,000 international students each year in their system, which is the student population of McMaster, which is, this historic, very well-known internationally recognized university. Just a ridiculous level of abuse. And as part of that, the province created the system, but then some of those unscrupulous, I'll call them, institutions were recruiting overseas, making these promises, bringing people in, not delivering. So my question, through you, Chair, to perhaps the Auditor General, is did we consider what role the provincial governments and also the institutions themselves had in the abuse of these programs?
So I can't look at the role that the provincial governments or the learning institutions played, but I would point the member, Mr. Chair, to Exhibit 5 in our report where we break down how the federal government interacts with the learning institutions. And the learning institutions are allocated a certain number of spots, and then or in each of the provinces, and the province decides which learning institution gets those spots, and then they can accept or not accept an individual or make an offer for them to come to school. But then that person needs to apply to the immigration department, and so they need to pass through two things: being admissible for immigration, but then also meeting the criteria of the program. So there is a lot of interdependency, and that's why I do believe that a better collaboration with the learning institutions and the provinces and the immigration department is needed to see why the intent was a lot sharper. Like the results of these reforms were a lot sharper than intended. Some provinces were meant to see an increase and saw large decreases. And so there might be some adjustment that's needed, but it's clear that there's a relationship between what the provinces do with the spaces that they are allocated, and then who a learning institution makes an offer to, and then how that person passes through immigration and then program admissibility. So I hope I've captured that well, but that to me is, it can't be done without collaborating.
Thank you. And I'll extend that question to the Department of Citizenship and Immigration as well. Just another example from Ontario, and that's my experience, so that's what I'm familiar with. But the system of colleges licensing their diplomas to third parties who are then basically packing strip malls full of international students, and they would graduate with an actual Ontario college diploma, even though the college was simply licensing that. So could the department comment further, please?
2 points. The first, the increased rigor in the financial requirements and the increased threshold will help mitigate and protect vulnerable students from being exploited in the manner you described. And then second, the SIM committee themselves produced a report with a much broader scope than the OEG's review. There are 10 findings, and then kind of an additional liberal finding, an additional conservative finding. J'ai pas noté de la bloc, mais c'est un bon rapport qui, je pense...
But it's a good report, which I think deals with the issues mentioned by the members, Chair, and we are taking due note of that report with the intention of having a government response within the timelines.
Thank you. Final question, then, and I understand we might be talking about this a little bit more, but on the timelines for security screening. So now that we've limited the number of international students, the final kind of frustration that I'm hearing from the post-secondary institutions is timelines for security screenings that don't necessarily line up with their admissions requirements. Could you comment on that, please?
Maybe I'll start from an IRCC perspective. We kind of triage and hand off to security partners. And so we are taking a look to make sure we're really managing risk properly. We have some categories where there's 100% referrals, and then we have these kind of roadmaps and journeys and criteria that we give to our officers to get referrals. And so one place we're starting is to make sure that those are effective and kind of using a feedback loop from the decisions to make sure that we're not needlessly tying up the intelligence community on cases that really ought not to be referred to them. But on the other hand, where there is a national security threat and a threat to the health and safety of Canadians, those cases are referred. And so that is one part of the kind of pipeline And then I would kind of turn to my colleague, Mr. McCrory, for the next part of in the processing chain.
Yeah, so we co-manage the program with IRCC and CSIS, and I'd say one of the things we've struggled with is how do we balance efficiency and effectiveness, and we do want to make sure that we can make timely decisions. Some take too long, but we also need to be effective in terms of ensuring national security. Part of the challenge that we faced is as I said, some decisions take too long, but the other challenge that we've quite frankly face is the volumes. And we've gone from about 50,000 people in our inventory in around 22, 23 to about 183,000 in our inventory. At the same time, our decision making has gone up. We did 106,000 decisions last year, but we haven't kept up with the volumes coming in. So we are looking at how can we become more effective in terms of working through them. Because for a simple stage one applications, we can do that in less than 2 days, up to a maximum of 2 days. Other complex one can take 14 days or more, but we need to get our hands on them, and that means getting the inventory down. So we've got two large pools. One is visa applicants, and those come to us based on referrals from IRCC, but we also do 100% of in-Canada asylum seekers, and what we're actually moving to is a more risk-based approach. Similar to what we do with visa applicants, we're looking at how can we use indicators and do based on country profiles, based on our assessment of risk, working with CSIS, how can we more rapidly say, this file doesn't need the full-blown review, and we'll move it on and come to a decision quicker. By making those decisions quicker, we can then turn our attention to those files that require more work. And so we're optimistic that we can put a significant dent in our asylum numbers in this fiscal year that will allow us then to put more energy into all the files that we have before us. In terms of students themselves, last year, again, we had about 180,000 in our inventory. We actually had about 1,800 students come to us. We had 1,800 files referred to us as students, and we made 1,200 decisions over that same period. So not where we want to be, but we recognize that we need to do more in that space.
Thank you very much. Suivant, c'est M. Lemire pour 2 minutes 30 secondes, s'il vous plaît.
Merci, Monsieur le Président. Monsieur Gallivan.
Thank you, Chair. Mr. Gallivan, according to them, there's 150,000 students not respecting the criteria of their study permits. What are the consequences for those people? Because clearly you have financing only to investigate about 2,000 cases a year. So to my mind, what's not acceptable is the non-response of those people who are simply ghosting you, as they say, and by not responding, then no consequences follow. So why wouldn't their permits be suspended on the spot? Is there a procedure when a student or worker no longer has a valid study or work permit? What happens to that person? But in the meantime, can we say you haven't responded or fulfilled the criteria? Your permit is no longer valid. Does that exist? The way you describe it, it does not exist as of now. And actually, that's why we submitted a plan of action to properly document things and make commitments to implement it. As regards the 153,000 cases, there again, once we examined it, which was not done when the OAG visited, we found that they had changed educational institutions, which is not fraud. It's simply a paperwork situation that's rectified, or they changed their status, or they obtained a work permit or a work visa. So that's not a problem. But there is a significant number in which there is a problem. So we didn't know how many cases to investigate, so the department decided on a budget for 2,000. I think, and we make the commitment to investigate all cases in which there is not a reasonable explanation, but really, in fact, a person who stays in the country when they ought not to, who is not studying or not working, and so on. We are undertaking to find the person and contact them, and you're quite right. Someone who does not respond ought to have 3 times as much effort and have their file before the file is closed. That's the spirit of the plan of action that we've submitted to the committee. Thank you. I like the frankness of your answer and your willingness to answer the concerns raised by the Auditor General. Mr. Macquarie, I have a question in connection with a case that is direct that we experience in Abitibi-Témiscamingue. If a student committed a crime and lost the right to be in Canada, what steps would be gone through to have that person leave the country, and how much time would it take before the person gets out of prison and leaves the country?
Thank you for the question. it's a hypothetical case, and as a general rule, we allow the criminal justice system to take precedence over the immigration system. So depending on the nature of the crime, if there may be serious criminal consequences to that, we'll allow the criminal justice system to take place, and then we'll be ready at the end of that to begin removal processes. In some instances, we'll work with local law enforcement, again, depending on the nature of the crime, and we'll say, well, we can do removal quicker than you can do work through the criminal justice system. And if you think of extortion, for example, the cases that we've seen in British Columbia, Edmonton, Winnipeg, Toronto area, we've actually been using our immigration tools to take individuals who've been involved in extortion and remove them from the country, and we've removed them fairly quickly. It's hard to say, though, in terms of the average time, because a lot depends, again, on the circumstances. Are they going to apply for a pre-removal risk assessment? Will they ask for a delay for health reasons? Will they appeal our decisions to the courts? Do they have a travel document? Is there an administrative deferral for removal in terms of where we take them to? So there's no hard and fast rule, but I would say that we have a legal obligation to remove people as quickly as possible, and we are. We did about 23,000 removals last year, and we prioritize those that are involved in criminality, or what we call serious inadmissibilities. Our second tier are those that are failed refugee claimants, and then third tier is everybody else.
Voilà, merci beaucoup. Up next, Mr. Carrick, please, for 5 minutes.
Thank you for everybody, all the witnesses, for coming here today. So I'd like to start by asking the new deputy minister that it's brought to my attention that you just started 4 weeks ago, correct? Great, thank you. I'll take your nodding as a yes, but yes, thank you. So in the IRCC, there was a testimony on Monday, and there was a lot of, I don't want to say excuses, but funding and budget those words were used repeatedly. So my thoughts and questions today will come from the public accounts aspect and protecting taxpayer money, or acting for the taxpayer, because there's some numbers here that I'd like to share with the committee and the witnesses. So the funding for the IRCC has gone from $316 billion to $6.5 billion in about 5 years. That also includes a doubling of the labor force from 2015 to 2023, from about 6,300 to 14,000. Those are big numbers. So the budget for the IRCC is massive, and we started to do this investigating, and this came after some testimony from the Auditor General that I found great for their what they told us about, but concerning. The Auditor General department, so their funding is about $127.5 million a year. They were able to find and help with finding the 39,500 individuals that kind of were they're not supposed to be here, and their office did that with the help of all the other offices, and they kind of did it upon themselves to find those numbers. What's concerning is their budget is very small, the RCC is very big. Now, obviously, the RCC does a lot more than just that, so I'm not going to dwell on that too much. But that's the point why I wanted to start on the dollars and figure out the dollars. But that also being said, there's a few other things that have come out today. My colleague from Hamilton raised some great concerns, some valid questions. The member from the Bloc Québécois also raised some interesting questions. We also heard from the Vice President of CBSA, and one of the things there I want to touch on was fraud, which led to the question of screening and communication between agencies. And the gentleman had said that they are figuring out how to balance efficiency and time and dealing with bigger volumes and looking at how to manage that. These are all valid questions. So as a member of this Public Accounts Committee, I would like to, at this time, actually move a motion, if that's okay.
You have the right to certainly state your motion. I'll have to decide if it's in order, Mr. Carrick. But
sure. So I can read my motion here. Yep.
May I just ask if you've submitted it with the clerk? Do you
Yes,
know?
I have.
Okay.
Yes.
Is it in both official languages?
Yes, it is.
Perfect. If it's all right with you, I'm gonna have the clerk distribute it, if that's okay with the.
Sure,
Is that,
of course.
Yeah, that way we can keep on track here. So yes, go ahead, Mr. Carrick, you may read your motion and we'll
Yeah,
do a quick ruling.
and so I'm moving this motion in just because I think we need to look a little
Tell you what,
deeper.
Mr. Carrick, just
Not a
give
problem.
us the motion.
Not a
so.
problem. In light of the findings in the 2026 report of the Auditor General of Canada entitled International Student Program Reforms, and given the additional concerns identified regarding oversight, enforcement, and the integrity within the international student visa system, the Standing Committee on Public Accounts write to the Auditor General to request that she expand the scope of her International Student Program Reforms Performance Audit to include A, the process and effectiveness of coordination between IRCC and the Canada Border Service Agency in tracking international students with expired visas, including data collection, information sharing, assessment for removal, and actual removals from Canada. B, the extent of non-compliance by designated learning institutions, including failure to report on student compliance, the identification of repeat offenders, and the application and effectiveness of law enforcement measures. C, the adequacy of procedures for verifying financial documentation submitted by applicants, including the detection, flagging, and the subsequent use of fraud indicators across immigration applications. D, the extent to which processing officers fail to act on or record indicators of potential fraud identified by learning institutions and the implications for reapplication and enforcement measures. E, the effectiveness and the integrity of risk assessment processes across all international student application streams, including the identification and mitigation of risk prior to and following permit approval. F, the handling of confirmed fraudulent cases identified by risk assessment units, including the absence of file flagging, enforcement actions taken or not taken, and the approval of subsequent immigration applications. G, the approval practices for study permits extensions, including the use of a light touch approach and the extent to which prior risk indicators or concerns are reassessed. And H, the scale of non-compliance among international students, including the adequacy of departmental resources for investigations, the thoroughness of those investigations, and the effectiveness of follow-up actions. And that the committee further write to the Auditor General to undertake an additional audit into an overall holistic security screening process across all program streams and how IRCC, Immigration, Refugee, Citizenship in Canada, the CBSA and the Immigration Refugee Board share information, interact with each other, and follow up on all cases of misrepresentation, fraud, serious criminality, terrorism, illegal border crossings, and all other reasons to deny permit approval from application and port of entry to final approval of permanent residency status or citizenship, including possible claims of asylum, expired permits, removal orders, detentions, pre-risk removal assessments, judicial proceedings, and all other steps inherent in the processes, and that the committee report this request to the House.
Thank you. Just hold for 1 second, Ms. Jim. So the motion's been distributed. It is a matter at hand issue. It is in order. Ms. Yip, I'm going to go back to Mr. Cure because I did cut him off when his intro. He does have that right, but I wanted to keep him in his time. I didn't actually know it would be quite that long, so I'm glad I did that. And then I'll come to you right after Ms. Yip. So, Mr. Cure, you have a brief statement to go along it. If you don't, that's fine. We can move things along, but back to you, and then I'll recognize Ms. Yip.
I move this motion in the spirit of true nonpartisanship that this committee actually represents. I do believe that there's been many questions that we've heard across the board and valid concerns from everyone around this table. So I believe this motion and the further reporting that I request, or that this motion requests, is going to be very, very important information for the Deputy Minister, who is brand new and to help him do his job better and help us help him. So that's my intent. Thank you.
Thank you. Before I recognize Ms. Yip, I will just let everyone know that what I do in these situations, I'm just going to take the temperature of the committee members. I'm going to see if there's something that we will resolve quickly or relatively quickly, or if it's going to go on for a while, and at which point I'll make a decision about what to do with our witnesses. So, Ms. Yip, you have the floor.
I'd like to suspend. This is a lot of information in your motion, and I'd just like to discuss.
So I'm open to doing that in a second. I'd like to do it one round though. So I saw Mr. Lemille, and I'll come back to Mr. Osborne, and then who I think had his yes, and then I will look to suspend Ms. Yip for a couple minutes at least for a discussion. But let's just do kind of a quick round here first. Mr. Lemille, s'il vous plaît.
Merci, Monsieur le Président. Je pense que
Thank you, Chair. I think the Parliament needs more net correct to present motions in an approach of collaboration to get to the heart of the matter and give additional powers to the studies that we're doing. So in that sense, the Bloc Québécois will support the motion.
Mr. Osborne, please.
Thank you, Mr. Chair. I always sort of take the approach that you act in haste, you repent at leisure. I think, this is a rather lengthy motion. I agree with my colleague, not just to suspend, but to give us some time to analyse this motion. The other thing that I would ask and request, we have witnesses here. Are we able to continue with the witnesses and deal with this after we're done with the witnesses?
Those are all good questions. I don't have on my own the authorities to kind of suspend a motion. It's now before the committee. What I'll do, I will suspend for 3 to 5 minutes, and I'll actually join the discussion on this about the witnesses. But the opposition member does have the right to proceed with this should he choose to do that. So I'll just state that up front. He'd have to yield that to the committee. So I will suspend for I'll suspend 5 minutes. So the witnesses, if you want to get up, stretch your legs, I would ask you to come back though in 5 minutes, and we'll have a little discussion and see where we're going to go. This meeting is suspended.
Okay, while they're suspended, we can tune into the Justice Committee. They're talking about Bill C-16, so
there's an erosion of trust
overly interesting,
and safety in the community. When that does not happen, it impacts my officers in London and their understanding and their confidence in the justice system. When serious offenders do not receive the sentences and the punishment that are reflective of the crime and the harm that they've caused to community and victims, that is a huge blow to policing and our officers.
Chief, we know London is experiencing increased gun violence, intimate partner homicides, and repeat offenders cycling through the system. Why should Parliament hand judges a blanket power to water down the very sentencing floors that target the worst offenders? And perhaps from a frontline policing perspective, will this so-called safety valve make your job tougher by encouraging lighter sentences for those very criminals that your officers arrest over and over and over again?
Thank you, and Chair, through you. I think the mandatory minimums that are imposed on the particular offenses that you're speaking of, or that we're speaking of, that involve harm and violence to the community, I think mandatory minimums are important. And again, the safety valve that is being proposed, I would say the positive aspect from a policing perspective is that in principle, when sentences are not being handed down reflective of the mandatory minimums that is in legislation, that causes challenges to our organization and policing as a whole.
Chief, I have about 30 seconds left, and given that your officers are the ones that are arresting these repeat violent offenders day after day, would you support splitting Bill C-16 so that the positive victim protection measures can pass quickly while the mandatory minimum safety valve is studied separately?
Chair, and through you, I would support the passing of Bill C-16 as quickly as possible.
Thank you. That's your time, Ms. Rood. Ms. Dillon, you have 5 minutes.
Chair, and I will start with Mr. Trong. You just mentioned the quick passing of Bill C-16 as being important. To follow up on that, how do delays in the justice system affect your ability to investigate crimes and support victims at the same time?
Chair, and through you, are you talking about delays? Delays. Can you be more specific with your delays that you're speaking of?
So delays in the justice system when it comes time to at the prosecution stage, I suppose.
I understand. So, Chair, through you, obviously we want justice served as quickly as possible. The longer the delay, the greater impact it has on victims for resolution. It also has impact on the offenders as well to be tried reasonably. So, of course, we want, when charges are laid, that the prosecution, that the case moves to the court as quickly as possible.
Perfect. And Bill C-16 introduces a 2-year delay before the coercive control provisions come into force. Given that these offenses require identifying patterns of provisions of behavior over time, how important is that period for ensuring police have the training and tools necessary to properly recognize, investigate, and apply these provisions?
Thank you. That's a good question. And Chair, through you, I think the 2-year delay with respect to that piece of legislation is very important, and it's, like I have already said, responsible. And it allows us to prepare for that new piece of legislation and the understanding of coercive control. It gives us an opportunity to ensure that we don't do any harm to victims as we interpret this legislation. It will require time for us to train our officers, work with the judiciary, and learn from community organizations and community groups and experts so that we get it right.
Perfect. And we are living more and more in a digital age, a digital environment. In your view, do the measures in this bill better equip law enforcement to protect victims, especially children?
Chair, and through you, I do. I think this is a positive step forward. I think that with this bill, we have to also think about the application of this bill and how Bill C-14 is a companion bill that is also important for us. With your comment about supporting and protecting victims, both bills have to be supported.
Thank you very much. My next questions will be for Mrs. Webb. From your perspective, are the proposed offenses and measures drafted with sufficient clarity to ensure consistent application by the courts?
Thank you for that question. I'm not sure if that refers specifically to the deep fake, for example, the new provisions that would apply to those types of offenses, or if there are other types of offenses that you had in mind.
You could speak to the deep fake ones, since we're seeing that more and more as well.
Yes. So the CBA actually supports many of the proposed refinements to those kinds of provisions. We actually indicate in our brief in considerable detail, I should say, probably in more detail than is useful for me to get into my response today, that perhaps there are some ways in which it may not capture certain kinds of images that perhaps might be, for example, like a fictitious or an imaginary animal, bestiality, those kinds of amendments. We think that we actually make some suggestions to refine them further to capture some certain other types of scenarios.
Thank you. And are there any amendments you would recommend to strengthen the bill while maintaining its objectives?
So we make actually a number of recommendations in our written brief, which is fairly extensive, and I should indicate that there are topics that I haven't commented on to date. For example, the admissibility of sexual activity evidence in the private records regime. I should say that the CBA is supportive of some of those proposals as well. We actually welcome some of those changes, but we also still have concerns about other types of changes. So, for example, the treatment of therapeutic records and what we view as being essentially an impossible standard to meet. So that's one area that we suggest, amongst others, that could be improved.
Thank you, Ms. Webb. Thank you, Ms. Dillon. That is your time. Monsieur Fortin, vous avez 2 minutes et demie.
Mr. Fortin, you have 2.5 minutes. Thank you so much, Mr. Chair. Police Chief Trong, I'd like to address something with you. In your presentation, you mentioned the importance of training resources, and a number of such items. I'd like you to provide us with some examples of training that's useful to police officers that doesn't exist now.
Thank you, Chair, through you. That's a great question, sir. I think when you're looking at coercive control, it's a nuanced offense. It is something that not everybody understands. We are, as police, we're used to responding to incidents where we see the crime evidently in front of us. As an example of an assault, you see an assault, you see the injuries, it's clear.
M'excuse de vous bousculer, mais j'avais 2 minutes et demie.
I'm so sorry. We have so little time. I have about 1.5 minutes left, so little. I understand that it's giving information to police officers about what coercive control consists of, right?
Chair, through you. Yes, sir.
Okay, merci.
Okay, thanks. In my last minute, then, I'll touch on another matter with you if we can. In C16, there are penalties for recruiting youth for criminal activities. You're receiving interpretation? You're understanding me? Good. Okay, fine. Thank you so much. I'd like to know if this seems sufficient to you. And if it is insufficient, I was thinking of the idea of imposing on adults who recruit youth, particularly criminal organizations who do so, that they receive 2 times the amount of sentencing time that the individual would receive if they had committed the crime themselves. So a Hells Angels member who commits a 12-year-old to carry out a crime could receive a mandatory minimum sentence twice as long. What do you think of that?
Through you, I hear what you're saying, sir, and I'm in full support of sentences reflective of the crimes committed. If it's a serious offense such as recruiting young people from an organized crime perspective, I feel the sentence should be reflective of that, and it should be a strong sentence.
Merci.
Thank you very much.
Folks, we have 6 minutes left. I propose to reducing the last 2 speakers to 3 minutes each, starting with you, Mr. Lawton.
Thank you very much, Chair. Ms. Webb, you mentioned your organization, as a general rule, does not support mandatory minimum sentences. Do I understand correctly that your view is that judges can be trusted to mete out the fair and appropriate sentence in basically in all cases?
I think that judges have a remarkably difficult job, particularly in terms of sentencing. And I think that judges across this country do a remarkable job of evaluating essentially, I think judges do a remarkable job of sentencing individuals as they should be.
So just to follow that to its logical conclusion, why have maximum sentences? Why have an upper limit for sentences if judges can just work within ranges?
Well, I think that's a bit of a different That's a bit of a different idea. And first of all, I would say that there are offenses in which the judges certainly do hand out maximum sentences. Not every offense. There are certainly certain types of offenses where we will rarely see, for example, a life sentence, but they remain on the books, and it's still a possibility that a life sentence could be imposed for certain kinds of offenses other than murder.
Thank you. I'm making the point that if we constrain sentencing on one end, it doesn't seem entirely abnormal to constrain it on the other end. But I'll turn back to you, Chief. We know that London is sadly, and it's not at all a reflection of your work, a hotbed in human trafficking just by virtue of where it is along the 401. Human trafficking, not something that's really dealt with in C-16, but we know there is a very direct link to, in some cases, abusive relationships and human trafficking. What can we do as a committee better,
I hate to
either
interrupt
through
him, but it looks like the other committee is back. Let me double check. Okay, they're coming back in any second. We'll catch it though.
with an eye to human trafficking? What would you like to see from legislation that would help that?
45 seconds.
Yeah, thank you, Chair. And through that's a good question, sir. I would actually say that coercive control directly applies to human trafficking investigations and human trafficking offenses. Oftentimes, the traffickers are involved in intimate relationships with the young woman or the young girl. So I think that applies.
Thank you very much, and I'm glad you were able to take up our invitation to join us here.
Thank you. Mr. Chang, you have 3 minutes.
We're changing the time.
Okay.
I'm going to take that, Mr. Chair.
Go ahead.
Thank you to my colleague as well.
Okay,
Chief, great to
that's a Liberal round anyway, and then they're suspending, so we can get back to this.
Note that the member is going to proceed with his motion. What this means to the witnesses, I'm sensing some broad possible goodwill here. Since we're still well within the 2 hours, I'm going to ask the witnesses just to hang tight, and we'll see how it goes here. And if we can resolve this in the next little bit, we'll come back to you, because I know many members would like to get through their questions. Some have not had the chance to do so yet, and that would be easier than having you come back at a later date. So there's really no speaking list, and I assume we don't want to go right to a vote. Is there anyone that would like to speak to the motion, make any amendments? Yes, Mr. McKinnon.
I think this is a very interesting motion. I think it's something that I could get behind, but I have some issues. One of the concerns I have, of course, is concern about the independence of the Auditor General, and we cannot be seen to be directing her to do anything. I have no problem with making a request to her to take action. So I would make a suggestion. So I would actually move to amend this motion. In the paragraph it says, and that the committee further write to the Auditor General to undertake. I think it would be clearer if we just change that undertake to be request. And secondly, at the end it says, and the committee report this request to the House. I would move to as well to drop that line.
I'm going to break those in two. I'm going to give you the floor. We're going to deal with that. So I think the first one, I'm going to make a friendly amendment to yours. Could we just make it the Standing Committee on Public Accounts request? I don't need to write. The auditor's right here. The auditor's team watches everything this committee does, and we will, of course, send the motion over. So you'll clear out my inbox a little bit if we just both in the first paragraph have the Standing Committee on Public Accounts request that the Auditor General expand the scope, and then in that paragraph you mentioned that the committee request the Auditor General. I've just got to work on this. Just 1 second. Hold on. And that in the last that second paragraph, and the committee further requests the Auditor General undertakes an additional audit.
I have a problem with undertake.
Okay. Then let's work. That the committee further requests an additional audit. Okay. Yeah. So, is that agreement? Okay, good. Mr. Osborne, do you want to speak to that, or could I just get agreement on that, and then we can move to Mr. Mr.
No,
McKinnon?
I was just going to suggest the wording we just arrived at.
Okay, great. So could I just have just kind of a show of hands? Yes, you agree to that change to really around request? Yeah. Thank you. Mr. McKinnon, now you have a second amendment, which is to remove and that the committee report this request to the House et que le comité fasse rapport à cette demande à la Chambre. That amendment is on the table. Would anyone like to yes, Mr. Danko.
Yeah, just on this is to be consistent, I think, with the various other committees that we're want to keep committee work in committee and House work in the House, and we have a fairly substantial full House calendar that we want to make sure that we don't inadvertently bring committee business to the House. So I think this is consistent with the other committees. It's also speaks to the efficiency of government. I think that we want to, keep the committee discussions at the committee level. Thank you.
Thank you. First, I have Mr. Stevenson.
I'll let Mr. Redikoff go first.
Mr. Redikoff, you have the floor.
Thank you. I'll be brief. The only thing that I would suggest to the committee is that in this particular case, the Auditor General has actually indicated that she prioritizes her work based on where the requests are coming from. And when they come from committee, they have a certain amount of weight. And when they come from the House, they have more weight. And so I think in this case, it actually has a practical application in terms of getting the attention of the Auditor General and priorities that she might set. So that's all. I just want to make that point.
Thank you.
Mr. Osborne and Mr. McKinnon.
Mr. Osborne, I think you were first, and then Mr. McKinnon, but at least according to the clerk. So, but you two are welcome to swap up if you like.
Yeah, thank you, Mr. Chair. To the last point made, I agree that committee work stays at committee. This doesn't stop individuals from asking questions in the House or to make put forward a motion in the House. Let's not be presumptuous on what the response of the Auditor General will be. I think we can remove this if this doesn't, if we don't get a response that is favourable to the committee from the Auditor General, then the House can proceed to, a motion in the House to do the same as this. But committee work should stay at the committee.
Thank you. Mr. McKinnon.
I was just going to say that I don't think the Auditor General needs something to catch your attention on this, and I would agree with my colleagues.
Thank you. Mr. Stevenson.
I would just emphasize that in our past, the Auditor General has stated to us that her priorities are always weighted by the House versus what the committees are, and the Public Accounts Committee is not exactly like some of the other committees, so I would say that it's still important for us to keep that in there to have the value to emphasize our importance to the Auditor General.
Thank you very much. I will call the roll call in on this amendment, and it is to remove and that the committee report this request to the House. Et que le comité fasse rapport à cette demande à la Chambre.
And that the committee report this request to the House.
And no, if you'd like to maintain the motion as it is. Would you call the roll call, please, Clerk?
Mr. McKinnon? Mr. Osborne?
Yes.
Ms. Yip?
Yes.
Mr. Danko?
Yay.
Mr. Dantel?
No.
Mr. Kirk?
Nope.
Mr. Stevenson?
Nope.
Mr. Lemire?
Contre.
And you have the casting vote?
So it's 4-4. I will cast the vote to maintain the motion as it is, and I vote no. We now return to the motion as amended. Any discussion or debate on the motion? Clerk, could you call the roll call on the motion as amended, please?
Mr. McKinnon?
No.
Mr. Osborne?
No.
Ms. Yip?
No.
Mr. Danko?
No.
Monsieur Datel?
Oui.
Mr. Couric?
Yes.
Mr. Stevenson?
Yes.
Monsieur Lemire?
En faveur.
4-4 casting vote.
4-4, I will vote in favor of the motion, so it is passed. And I will now return to the round of questioning. We're just at the end of the second round. Mr. Osborne, you have the floor for 5 minutes, please.
Thank you. Let me gather my thoughts for a moment. I'd like to ask, and I guess this is really for IRCC, in a province, a small province like Newfoundland and Labrador, the Auditor General has pointed out that they were disproportionately impacted by the decision of IRCC. Can you speak to what has been done to rectify that? I know I was a member of the provincial legislature actually when this had transpired. Can you speak to what has been done to rectify the difference where Newfoundland and Labrador should have seen an increase but instead had seen a decrease?
I'll just make a couple quick points and then turn to colleagues to kind of detail it. But starting in January 2025, changes were made to the provincial allocation, so that wasn't in time to be picked up by the OAG's report, but that proactive adjustment process started already. This spring, we are engaged with provinces to really understand how we can tweak the allocation model and customize to help address the concern you're expressing. We've also committed to giving them better data and better information so they themselves can plan within their jurisdiction. So very respectful of the shared their responsibility for education, and so giving them data. And then finally, we've committed to another round of tweaking this fall. And so, Alexis, I don't know if you want to kind of detail some of that for the members.
Yes, I'm happy to provide additional details. So, I mean, I think we completely understand and agree that attraction in smaller centers is a challenge, and that the changes certainly have had impacts across the countries and in smaller jurisdictions. We have embarked on a fairly detailed and robust engagement plan with provinces and territories to really better understand what is causing approvals versus refusal rates. And we have also adjusted the allocation formula to take into account the approval rates of certain jurisdictions. So in practice, that means that we will kind of give more allocations to those where we are seeing higher refusals so that they can add more students to that and so they don't get kind of penalized. But in general, these are conversations that are happening through multiple layers, starting from the minister, going down to working groups, to really unpack that, share information, generate more complementarity between the programming, and really understand what is at the root of this so that DLIs and recruitment efforts can focus on the students that are going to be successful.
Thank you. I appreciate the answer. How do both agencies, I would think, balance the reduction in new arrivals with the need to attract and retain skilled workers, especially in areas where we have skilled labor shortages, medical health professionals, for example?
Again, I'll make a brief start and then turn to Alexis. But, you know, there were two prongs to the strategy that was initiated in 2023. It was both to get the numbers and the integrity under control, but also increase the quality. And so in terms of the definition of that and kind of working with jurisdictions to make sure that, you know, world-class students that really make a difference in terms of the Canadian educational landscape are there. And so, Alexis, do you want to kind of come in a bit on the quality aspect?
Yeah, I mean, I think in terms of the volumes, that is, and just the composition, we do see that there is a shift. So just for example, the proportion of university-bound students is back to pre-pandemic volumes of about 40%. So it's shifted away from colleges and back into that kind of university space. And we also see that top research universities are leading the new study permit recipients and are welcoming more students in STEM. So, for example, it's up 3.6% from 2024 to 2025. And there are fewer kind of in those oversubscribed business programs. So we are seeing some adjustments already and some changes in those behaviors and those outcomes. And I would just also note doctoral students applying to study in Canada and their family members now also benefit from 14-day processing. So we've really tried to speed that up for that particular cohort, and IRCC is meeting that commitment.
Thank you. I will commend the Auditor General for bringing some of the concerns to light. I'll commend IRCC and Canadian Border Services as well for how you've reacted to those recommendations. I want to ask both agencies if you can expand on some of the improvements that have been put in place as a result of the findings of the Auditor General, including the fact that last year you reviewed 100% of the potential fraud cases. What brought you to be able to do that? For example, what measures were put in place? What other improvements were put in place as a result of the recommendations?
Maybe I'll start, Mr. Chair. So it was unfortunately the Auditor General who shone a spotlight on these discrepancy letters, the 153,000. And so it wasn't, in fairness, till the OEG arrived that we started looking at those in detail. I would say that the letter process was new. And so there was a sense, I think, within the IRCC that the number would come down naturally as people got used to the process, and there would be filler mistakes. And, after several years, it would be a good time to kind of pounce and start looking in kind of detail. And so I think what I would describe, Mr. Chair, was a process of weeding down that list, but we're not done. And so there is work ahead of us in terms of confirming whether the people without status have effectively left the country or not. And so I don't want to leave this committee with the impression that the work is done. We have narrowed the list down to people who don't have valid status in Canada, but we have yet to fully confirm that they have actually left the country or not. And then finally, the hard work, people who ought to have left the country who haven't, that's going to be tough work. And that work is ahead of us, Mr. Chair.
Thank you. That is your time, Mr. Osborne. Beginning our third round, I'm going to go to Mr. Stevenson, I believe, to kick us off for... Yes.
Thank you. I have several questions, but most of them have been partially answered, so I'll try and be a little succinct on these. First one will be to the Auditor General. In your audit, when you found those fraudulent cases, did you have any link? Did you see any pattern within those cases that linked them to specific institutions?
So I think you're talking about the 800 cases. Yes, so those were identified by Immigration Department. What we did notice as a pattern from them is a little over 700 had claimed that they had attended an educational institution that just did not exist.
Was it all the same one, or was it multiple different names that were...
I'm going to have to ask if someone has that answer just across the table from me. I don't think we have that answer, but I think it just shows the majority of them had that as a fraudulent documentation.
Hell?
That would have been an alert, something that the Immigration Department should have seen.
And again, with those numbers, was there any indication of an agency or an individual that was promoting this to say, hey, come to Canada through this student area, and this is your path, and so there's no real link between the individual cases?
So we didn't go that far into each individual cases. The patterns we did notice, as I said, was that over 700 of them had this one fraudulent letter or claim of an institution. About 68% of those 800 were approved through the student direct stream. So we were again connecting to a bucket that came through on a lighter light touch, faster process. And so this just raises other flags around having a control is good, but the control is only as effective as the enforcement and the follow through.
I'll go to Mr. Gallen or Mr. Graham going through that. Just on they talked about the light touch. Is that part of your, as you said, plan of action that's to be completed in 26? Is the light touch being addressed as to maybe that's not a good process going forward?
I think there's two parts. The program itself, which was a lighter touch, was discontinued, so that's happened. Now we have the students who were ingested during that lighter touch period who are still in Canada and have transferred, and that's where we've taken a commitment in 100% of the cases to take into account that they receive less scrutiny. And so if they're renewing their student visa, extra scrutiny, and so I think it's managing the population that came in while the program was live.
So just going on an extension of that, it seems to me that we had discussed earlier that there was a doubling of the number of people in your department. So it's, by the sounds of things, your plan of action is not that you needed more staff to do this, because now you're doing the 100% follow-ups on those, but you didn't before. So that was just, was that a choice by the department, or was that indicated before? Save some money, and this is how they plan on doing it?
I think in a first instance, because this was a new process, this idea of letters was a new process, I think now that, let me say this bluntly, the number of suspected fraud cases should drive the allocation of resources rather than a fixed budget that management decided. And so, the commitment we're trying to take is that we do have sufficient resources, although 14,000 is a little bit generous. We're not quite that large, but we have sufficient resources. We ought to reallocate resources to deal with the risk.
So can you just tell me, as a percentage, I don't know if you have numbers, you probably don't have the numbers, but as a percentage even, or you can get back to us later, in your department and in your process, how many people are actually focused on just investigating the claims versus administration of the rest of your program?
So I've asked the same question. Part of the challenge is we have visa officers who are both facilitators and compliance officers. They get a visa application, and it depends on the veracity of the claim. That wasn't a very satisfying answer to me, but that's where I am right now. We have very few full-time compliance officers. All of our officers, when they look at a visa, are thinking compliance and service, and it's really the nature of the application and the facts of the file that dictate whether they're facilitative or not.
When you get to the bottom of those and you find somebody that should not be involved or should fail the system and get kicked out, how are you doing like a data dump to the other departments to say, hey, here's all the individuals now? Is that part of your action plan?
So part of the action plan is to dedicated compliance teams. So that would be kind of the second tier. So the visa officer, we got a problem. In a program, we have a problem. We are striking dedicated compliance teams. So I'll have a better answer in terms of how many people work full-time on compliance going forward. But we want to take the first cut before it goes over the wall to the CBSA, because again, sometimes somebody has merely failed to inform us of changing educational institutions. That's not okay. We have to enforce it. But I think it's premature to kind of initiate a forced removal until we ascertain that's the circumstance.
That is your time, Mr. Stevenson. Suivant up next, Ms. Yip, for 5 minutes, please.
Thank you for staying longer. This is for Ms. Hogan. I believe Mr. Osborne had touched on his province. In the report, it says the reduction in new study permits disproportionately affected smaller provinces. Why is that?
I think there was a compounding effect there. The first allocation model assumed an approval rate of all applications received at about 60% when each province has a very different pattern. And as was already mentioned by the Deputy Minister, that got adjusted as they fixed the allocation model. So I think the drop in actual applications, then the application of an approval rate that was not an accurate one for the province made a bit of a compounding effect on a province. And that's why in April of 2024, I believe there was a top-up done. But that top-up still hasn't compensated for the disproportionate impact.
Mr. Gallivan, did you want to further comment on that, or Ms. Graham?
Thank you for the question. And I think, it is clear that the change and the transition with CAPS and the new requirements did have an effect. And so as part of the action plan, you will see that we do plan on undertaking multiple touch points with provinces and territories in support of maximizing the utilization of those allocations. So we have a series of kind of meetings that will be taking place in terms of sharing data, understanding what is the reason behind refusals, so those behaviors can change and recruitment patterns can change as well, hopefully transitioning to a more ample use of those allocations. And then we'll have a tracking, of course, throughout that to see if we are actually achieving that objective, and we'll course correct as necessary with them as essential partners in this particular objective.
Approximately 40% of cases were not closed because students did not respond to requests for more information. How can you compel students to respond in order to close the cases?
It's interesting because at committee just Monday, there was a bit of a conversation and then a sidebar between CBSA's president and myself, Mr. Chair, on this very question. And so to show where focus and prioritization is important, we were talking about an indicator in the border system. And so if that student who's not talking to us travels out of the country and back into the country, there should be an indicator to CBSA that says we're looking for TID. And so I think it's really designing a compliance framework around that. And, for IRCC, there's been a lot of focus on the front end, a lot of focus on helping refugees, on helping facilitate, but we need that same energy to be applied, I think, to the back end. And so an example of how to find a student is put an indicator in the border system, and if that person ever crosses the border back and forth, then we're able to force a conversation. And that's just one example of how we need to think through a compliance framework that kind of puts some teeth into the process.
Yes, I did wonder. I often find it hard to track my own kids. So, how else is CBSA collaborating with IRCC?
Thank you, Work Club, for another super chat. Really appreciate you.
In this particular, and thank you for the question, Mr. Chair. In this particular instance, we're deeply implicated in the MRAP itself, not in the Management Response Action Plan, and so we will be working with our colleagues at IRCC in fulfilling the commitments in that action plan. But I'd say we work together on a daily basis in terms of it's as I alluded to earlier, I think of it as a continuum of activities. When you think about somebody coming into the country, when somebody gets a visa, it starts with the IRCC, but then they send some of the visa applicants to us to the security screening. Then we send the recommendation back. When somebody arrives, we do the processing at the border. They're doing the integrity checks for the student program in country. So not all of our systems are automated. None of our things are perfectly aligned from a communication point of view, but I think the staff and the people are constantly working together on a daily basis. Going back to the question of our security screening program, for example, we have an ADM meeting, or an ADM committee that governs that program. It's all three agencies that are involved, and so we collaborate every day on these issues.
Yeah, this is not the time to work in silos. I had a question about the student direct stream, and that IRCC was slower to respond with the integrity concerns. What is being done to rectify that for the student direct stream?
So, Mr. Chair, back to earlier testimony. So that program was discontinued, and so that's positive going forward, but we are left with the legacy, I think, of a cohort that we're subject to less rigor than we would normally apply. And, back to the risks of fraud and what we're worried about. In some cases, the risk was asylum claims. Well, they might have claimed the asylum already, but it's working through that population as they seek new visas or seek renewals to make sure extra rigor is applied because it wasn't applied in the first instance, and then managing it as a population again around something like the departure date. And when your visa expires, you really ought to leave the country. And so we'll lead with education and compassion, and then kind of turn up the heat to make sure that people follow the rules.
Thank you. That is your time, Monsieur. Suivant encore une fois, c'est Monsieur Lemire pour 2 minutes 30 secondes, s'il vous plaît.
Mr. Lemire, 2 minutes and 30 seconds. Thank you, Chair. A quick question for written documents, and then after that, I'll table the motion once again that you already saw. Mr. Gallivan, you spoke earlier about a new IT program launched for the end of the term of the permits. Could you give us an estimate of the program costs and the actual costs incurred so far? It would be interesting to see, and I'd like to have an overall estimate and expenditures so far, breaking down by phase for the modernization of the platform, the digital platform. And if you could be good enough to send it to the committee in writing, this is something of particular interest to me, the computer or IT services contracts and the mechanisms of those contracts. Thank you for agreeing to that, and I can see you nodding. And just for the record, which doesn't record nodding, could you please mention? Yes, I understand the two-part question, and I will send it in writing for better information, and I undertake to act as soon as we get the information. Thank you, Chair. I have another motion connected with IT programs. There was a debate in the House, and during this debate, the Parliamentary Secretary, Mr. Lamoureux, raised the fact that parliamentary committees were the right place to be able to shed light on programs and reports connected with the government. So I take note of that and at its face value. So given the response of the government and the additional information providing report one delivery benefits delivery modernization program published by the Standing Committee of Public Accounts and the payment delays for 60,000 seniors, the committee undertake a follow-up study that the committee requests that the Department of Employment and Families, the Department of Government Transformation, Public Works and Procurement, the Privy Council and Prime Minister's Office provide the clerk of the committee with 30 days of the adoption of this motion, with all reports, correspondence, emails, and documents relating to the management of the modernization of benefit payments since January 1, 2017, and that the departments and the Prime Minister's Office responsible for producing the documents apply redactions in accordance with the legal obligations set out in the Privacy Act and the Access to Information Act, and that the committee hold the first meeting on this study 1 week after receiving the documents, that senior officials from Employment and Social Development Canada, Services and Procurement Canada, Shared Services Canada, and the Treasury Board, that Cliff Groen, former Associate Deputy Minister and Business Lead Benefits Delivery Modernization, and John Ostrander, former Technical Lead Benefits Delivery Modernization, be summoned. I think there are going to be some proposed amendments, Chair, but that is the motion as presented. I think you're correct.
This is going to be very quick because we're running up against the clock. I'm going to suspend for 2 minutes. I'm going to take the temperature of the room very, very quickly, and then we'll come back to Monsieur Lemire, and then we can see what amendments we have. So just a 2-minute suspension, please.
Okay, we'll tune into the Justice Committee to see where they're at.
Practice evidence
just going to be on a motion
that coercive control is central to child abuse, exploitation, and trauma, including cumulative harm and harm to children who witness this control. This omission leaves some of the most common and damaging forms of violence against children legally under-recognized and structurally invisible. Finally, formalizing consistent trauma-informed frameworks, including the presumptive admissibility of high-quality child forensic interviews that meet national standards, would strengthen evidentiary reliability while reducing re-traumatization of children. This approach better aligns legal process with what we know from research about child development, memory, and disclosure, while both improving fairness and efficiency in prosecutions. These areas for future reform would complement Bill C-16 and further align the justice system with the lived realities of the child victims. I want to emphasize from this research and practice-informed victims' rights perspective that the real impact of Bill C-16 will be determined not only by what it promises in legislation, but by how it is implemented, enforced, and resourced. For children and youth, legal rights that exist in theory, but that are applied unevenly, offer little protection in reality, particularly when the victim has no independent power or advocate within the system. A trauma-informed justice system requires deliberate implementation, clear accountability, and sustained investment, including training for justice actors, infrastructure to support testimonial aids, and mechanisms to assess whether the reforms are being realized consistently across jurisdictions. Importantly, much of this implementation capacity already exists. The National Child Youth Advocacy Center Network provides coordinated, victim-centered, and trauma-informed systems whose core mandate is child protection and victim support. Strengthening this network of 51 across the country is a practical and efficient way to ensure that Bill C-16 translates into real protective change for children, not just procedural reform on paper. I want to thank you for this opportunity to speak to this bill in ways that can meaningfully improve safety, participation, and outcomes for children across Canada. Thank you.
Merci, Madame Parker. Dr.
Thank you, Dr. Parker. Now we will move into our first round of questions. Ms. Cronus, you have 6 minutes. Thank you, Mr. Chair.
Oh, Brock left. Brock's not even in
It's
here anymore.
always a pleasure to have someone here from my home province of British Columbia. I want to pick up on your comments about the justice system not being designed with children in mind, and the opportunities that you described to build on what's being proposed in Bill C-16, and in terms of the importance of ensuring that children feel supported, safe, and believed. And in particular, online child sexual exploitation cases in BC have risen dramatically, as you know, more than doubling between 2021 and 2023, with the BCRCMP reporting almost 16,000 cases in 2023, up from 4,600 in 2021. And what I wanted to ask is, Bill C-16 does include measures to protect children and address exploitation. But from your perspective, does it prevent repeat harm from known offenders?
Can I just ask you to repeat that? Sorry, one more time.
I was wondering whether or not you see anything in Bill 16 that helps prevent repeat harm from known offenders in the context of the explosion in child sexual exploitation cases that we see in BC.
I don't know if I have a solid answer to that, but in terms of supporting children, our child and youth advocacy centers are designed to support those children when they come in through our doors.
Thank you for that. And could you speak a little bit to what happens to a young or disabled person psychologically when they're targeted multiple times by the same individuals?
Well, when we see children having, sorry, just give me 1 second to organize my thoughts here.
While you're doing that, Ms. Boost, I might turn to you. How easy is it to keep offenders off of technology when they're out on bail?
Are you speaking to me? Sorry.
Is she new to the committee?
I'm sorry, Ms. Jolie. I apologize. From Boost. Sorry.
Okay, that's fine. Can you please repeat the question for me?
So I'm wondering how easy it is to keep offenders off of technology when they're out on bail.
That's an interesting question, and one that I think is outside of my scope of expertise. That would be, I think, as part of bail conditions, which I'm knowledgeable about, but certainly not an expert in this area. Speaking of, you asked a question earlier about repeat offenders, and I think that adjustments to the Mandatory Reporting Act seen in Bill C-16 would support that reduction in repeat offenders by law enforcement having access to fulsome materials when they're conducting an exploitation investigation, where they have full records and they have the
preservation period is extended, I believe that would allow for better evidence collection, therefore giving more information and maybe better being able to bring that individual to justice. So I think that could be a relation, though I'm not a law enforcement expert. I'm only speaking to my experience working in the child advocacy space.
Thanks. I'm actually coming at this from a place where we've seen high recidivism. And I'll give you an example. A Nanaimo man was arrested just a couple of weeks after being released on a child sexual abuse possession charge. And you went into detail about the steps of exploitation. You talked about the grooming and the threats. And what I wanted to ask you about is every single one of those things is a separate offense. And in circumstances where someone, say, shoplifted and then stole and got arrested and was released and then stole a car, or when we've got a lot of situations locally where someone goes back to the scene of the crime. And what happens is that each time that counts. But in terms of trying to decide whether or not the person will be let out on bail the next time something happens. But in child luring cases and in child sexual exploitation situations, a lot of time we don't actually find out that 4 or 5 crimes have been committed until after the person is arrested, because the luring is a crime, the threat is a crime, the creation of the distribution of the material is a crime, but it often gets characterized as one offense. And so one of the things that Bill C-16 doesn't do is remove the principle of restraint in bail conditions. And I'm wondering whether or not you think it would be important for this bill to recognize each of the crimes that are encapsulated in a single charge as a separate crime for the purposes of bail.
En 20 secondes.
In 20 seconds, please.
That's a really big question. And again, I want to say it's a little bit outside of my area of expertise. I think that bail conditions are a really important aspect of the criminal justice system, particularly for our young victims. It is often the only things that are keeping that child safe or allowing that child to have a sense of safety, because so often offenders are released while they're awaiting trial. So though I can't speak specifically to it, I do think that any way that we can increase those.
Thank you, Ms. Jolie. Thank you, Ms. Cronus. Mr. Chang, you have the floor for 6 minutes.
Ms. Dill, from your perspective, how important are the protection in Bill C-16 for improving outcomes for young victims?
When it comes to things like testimonial aids for children, we're definitely seeing progress in the right direction. However, there are still opportunities within the bill to strengthen those responses for kids. We know that testimonial aids reduce stress and trauma for children participating in courts. They support clearer, more complete evidence, and without them, some children are unable or unwilling to testify. So this really is about when we're strengthening those aids, we're making participation possible, and we see a direct difference in how children engage when those supports are in place.
Thank you. And could you please speak to the importance of trauma-informed approaches when prosecuting offenses involving children?
Keeping children at the center is absolutely critical. We are always, the goal really is around being able to balance participation in the system and procedural fairness. But that's really ensuring that children have a voice and that they have an opportunity to be heard. And that the system is wrapping around them to reduce stress and support their participation in the process so that they can get on the path to healing.
Thank you. And how do measures like evidence preservation and strengthened tools for online harms support the work being done by an organization like yours?
I'm sorry, can you repeat that question?
How do measures like evidence preservation and strengthened tool for online harm support the work being done by your organization?
There wasn't much English there.
I think what I'm going to do with that question, it might be better to be directed to Dr. Parker, who has some of the background on forensic interviewing.
Thank you, Leah. I will answer a little bit about child forensic interviewing, but I believe you were asking beyond that scope as well with the online harms. But children give their most accurate evidence when they're interviewed once early by trained professionals, and yet our system still relies on repeated in-court testimony, which re-traumatizes children and degrades their reliability. So presumptive admissibility of high-quality forensic interviews would reduce that harm and improve evidence quality and strengthen, not weaken, fair trials under Bill C-16.
Okay, and are there any additional support or resources needed to ensure that these legislative changes are effective in practice?
If presumptive CFIs were included, which is not currently in the bill, but if it was, we would need to set up national standards. There is evidence-informed protocols that other countries have adopted, such as the NICHD, which is the acronym they use, and the training would need to be standardized across police forces of how they're implemented. In terms of further training, there would also need to be judicial training on the understanding of how those child memory plays into the child forensic interviews and trauma-informed adjudication beyond kind of the sexual assault myths, which currently exist. That training currently exists.
Thank you very much. My next question goes to Ms. Hajek. Elder abuse is often non-physical. Does the current legal framework adequately capture coercive and controlling behavior?
Not necessarily, no. And what we're trying to do by providing some insights around this is to make sure that coercive control extends to all persons that are relevant in the older person's life.
Thank you.
Providing care, formal or informal.
Thank you. And would Bill C-16 improve protections for seniors, or do significant gaps still remain?
Again, we want to ensure that the language includes older adults and those people that they have relationships with and that are providing either basic necessities of life or within their social support networks. As it is right now, it's not sufficient in terms of capturing that target audience.
And what are the biggest barriers preventing seniors from reporting abuse, from your experience?
The list is long, but first and foremost, it is the stigma of suddenly being judged that they have allowed this to happen to themselves, or the shame of disclosing to other individuals. More importantly, if the older person is actually living in the same home as the abuser, there is always that threat and fear of repercussions of actually reporting it. And for the most part, most adults do not want to incarcerate their family members. They just want the abuse to stop.
And I will go to Dr. Parker again. Your research highlights early warning signs. At what point should intervention occur to prevent escalation?
Escalation of abuse?
Yes.
I believe that by strengthening the I'm not going to speak about the mandatory reporting as much because my colleague Lindsay did, but there is training that could be done for allied professionals in the recognition and reporting of abuse because there is very clear signs of what that looks like. And we know that abuse that is repetitive and coercive, it has incredible harms. And that does also connect to, although it's not what you're asking, about the need for graduated charges.
Merci, Dr. Parker. Merci, Monsieur Chang. Je vais donner la...
Thank you, Dr. Parker and Mr. Chang. And I now recognize our eminent colleague, Mr. Fortin. Eminent colleague, I'm sorry. First, I'd want to thank everyone for being here. I have a question for you, Dr. Parker, regarding recruiting youth. C-16 provides for a specific sentence with a mandatory maximum of 5 years.
Let's get back to public accounts. Is it still not back? Okay, still not back. Why is this Bloc MP the frickin' chair?
And having them commit crimes. Does this seem sufficient, or should it be more, or is it just useless?
Thank you for this question. I'm not necessarily prepared to speak to the sentence length, as that's not my area of expertise, but I will say from decades of research and frontline experience, this type of coercive control is central to child abuse and sexual exploitation. Children are controlled through fear, dependency, and that normalization, and they will do things even though without physical force, but because they consent, because the resistance feels unsafe or futile, and that is a heinous crime that needs to be considered seriously.
Merci, Madame Dr. Parker. Madame Joly.
Thank you, Dr. Parker. Ms. Joly, could you answer that question as well? In your opinion, does C-16 correctly deal with the issue of recruiting youth to crime?
I have to echo my colleagues' comments. It's not my area of expertise to talk about youth and crime, and I'm not prepared to be able to respond to that.
Okay. So any one of you have an expertise in peut-être Madame Zil?
Perhaps Ms. Zil? Do you have an opinion on recruiting youth?
Yeah, I think it's important to recognize that the work we're doing in child and youth advocacy centers is around supporting the victims of crime. And so recruiting into isn't the area of expertise, and I don't have that expertise to be able to comment on that or have an opinion specifically on that piece.
What do you two have expertise
Madame Hajek.
Thank you. Ms. Hajek, I understand that your organization, are working on elder abuse. It's a topic that touches me. I think it's as important as harm to youth. These people, elders, are often defenseless and need better protection. C-16 sets in a certain number of measures, for example, the whole matter of patterns of coercive or controlling conduct. I'd like to hear you on that. That could surely help your clients. But what else? What other measures could help better protect elders?
I think just the recognition that regardless of the language that we choose in the legislation, it is essential to take this back to the experience of the older adult themselves. More often than not, they're afraid to disclose and they cannot tell their story. If they remain in isolation and behind closed doors, then that escalates and often does lead to homicides or other worse things than that. It's important for us to be able to have conversations with older adults and to have an avenue where they are feeling that they are empowered to safeguard their own selves in community. So it really comes down to everything that we do as an organization is through that preventative lens. So we're trying to educate older adults to look out for things like frauds and scams, but the coercive control piece, it does limit a person's life. When someone is taking control of the older adult's finances, they have limited healthcare access, and often that can lead to mortality as well.
Vous parlez de mieux les éduquer. Est-ce que les outils...
All right, you're mentioning providing them with more information. Are the tools currently available sufficient, or should we think of providing new tools for informing our elders about how to prevent fraud and prevent abuse, prevent being victimized, in your opinion?
I think that our organization, as well as the organizations across Canada of my colleagues that are involved in various provinces and territories in this work, there is a lot of resourcing that's out there. We have helplines, we have different information and referral services. But for the most part, if the older adult is coerced where they are isolated from the community and they don't have access to those resources, there are other measures that can be put in place. For example, working through local police departments to do wellness checks, not necessarily showing up at the door in a uniform, but just checking in, and also teaching our neighbors to be able to check in on their neighbors. If you haven't seen somebody for a few days, what's to stop you from knocking at the door and just saying, I haven't seen you for a while. Is there anything else I can do for you? As a society, we have an obligation to look out for each other and to be supportive of those that don't have those resources. Excuse me.
Merci. Vous avez probablement vu, Madame Hajek.
Thank you. You've probably seen, Ms. Hajek, as well, that we are addressing femicide. Can you have anything to say about that topic. Is feminicide an issue among elders, or as of a certain age, is it less frequent? What do you have to say?
In 2024, for example, there were 7,622 police reported senior victims of family violence. In Ontario, nearly half, were 47%, were victims, femicide victims, and most of those were over the age of 55. They were killed by a family member, and more often than not, the accused was their son. So it is escalating. There have been different review committees that have commented, like the Ryan inquest, for example, and there are recommendations within those inquests on how to deal with it.
Merci, Madame Hadjek. Mon temps est écoulé.
Thank you, Ms. Hadjek. Even my time runs out. We will now hear from Mr. Lawton. 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
Bien fait.
You did well.
To begin with you, please, Dr. Parker. You mentioned in your opening statement that you would propose graduated offences and have a range there. We haven't had the benefit of receiving your brief yet. Could you just explain what it is you're referring to there, please?
Absolutely. Thank you. Graduated offences. Our current criminal law treats child sexual abuse as kind of discrete acts, and there's one criminal code section 271, which is the one charge that's available. And that means that without graduated offense categories, very different forms of sexual abuse, for example, an unwanted touch of a breast or long-term repetitive penetrative sexual assault, are absorbed into the same charge, and it obscures the differences in severity and impact. And this directly contributes to the inconsistent charging and sentencing, and that can leave survivors feeling the system did not fully understand what happened to them. It also does not give police and prosecutors clear tools that can help them better match the realities that they investigate. And that's why I paired that conversation with the conversation around mandatory minimums.
Yes, and I realize and respect that your expertise is on the victims and not necessarily on the law itself, but is your view that that would perhaps insulate us from having to deal with a safety valve and having to deal with some of the reasonable hypotheticals that could come up in a legal discourse surrounding mandatory minimums, because there's so much latitude under the current set of what would currently be captured by the offence versus what you're proposing? Is that essentially what you're getting at there?
Definitely not a constitutional lawyer, so not going to speak about the safety valve, but I do think that the graduated offense categories, which we have heard repeatedly from police officers that we work with, would help them in the investigative process and be able to recognize the harm and the that is happening to the victims and the level of evidence available to support them.
And just to confirm, you have submitted to the committee clerk already that recommendation in writing?
That recommendation specifically is not in our brief, but I can follow up.
I would very much appreciate if you could, and very quickly as well, because we're going to be doing our...
Juste une seconde, Monsieur Lawton, on va arrêter votre...
1 second, Mr. Lawton, and we'll stop your time. Ms. Parker, could you speak a little more slowly, because the interpreters are having a bit of trouble interpreting you. Thank you.
Thank you. Usually it's I who has to slow down speaking, so welcome to my world, Dr. Parker. If you could submit that and do it rather quickly if you're able to, as we'll be doing clause-by-clause review on Monday. I'd be very interested in seeing what you believe would help the legislation here. Just on the victim side of things, I have spoken to the committee before about my experience. I was a victim of sexual abuse as a child, and when I was grappling with this as an adolescent and into adulthood, the idea of having to testify about it was a terrifying experience even then. And I know for children, it's they don't even have the maturity or awareness to know to be terrified, because it is such a foreign experience. We also have due process. And anytime justice legislation comes before this committee, we end up in this back and forth where victims' rights seem to be subordinated to the rights of offenders and whatnot. So could you just speak to, from your experience, the lasting scars that can come not just from the victimization, but from the way that the legal system can aggravate and recreate that victimization?
Absolutely. The justice system as it exists right now is driven by system capacity and fragmented investigations and repeated adjournments. So often children wait years over a course to provide their case, and their disclosures are duplicated or trials are postponed. Children's memory, we know, not changes, but their memory is affected by their developmental stage as well. And so when they have to tell their stories repeatedly, when they are questioned in a court, it absolutely creates trauma. And we know that children and youth are recanting, choosing not to participate in the system because it is causing so much harm to them.
Dr. Parker, vous essoufflez nos interprètes en tout respect.
I'm so sorry you're tiring our interpreters. We would really ask you to slow down. Thank you. It's not your fault. It's the system. It's the system that's not working quite as it should. Thank you.
Trying to help me maximize my time, nevertheless, Dr. Parker. Just one final question I'll ask you. When we have these discussions, how much of this do you believe is a legal issue that needs to be solved within the legislation versus a training issue and an awareness issue that needs to be dealt with through the provincial court systems and also through police agencies?
I definitely do not see it as a black and white either or. There is definitely system capacity issues, but the system is trying to do everything for everyone. You need to protect the accused rights, the victim's rights, and the system itself. So definitely there is training issues, but there is also judge and Crown prosecutor capacity issues. At LUNA specifically, we can assess a case within 4 days.
Merci, Dr. Parker. Merci.
Thank you very much, Dr. Parker. Sorry for the inconvenience. And now the floor is Mr. Housefathers and Ms. Dillon. I understand that you are sharing the time.
Okay, we can call it here because it's just going to go to a lib round for the last 5 minutes, and then that's it. This committee ends in 3 minutes or 5 minutes anyway because they started a few minutes late. But that's it. That was the last of this. Like I said, our committee that we were originally watching public accounts has suspended. It doesn't look like they're coming back. That motion that they moved, I guess they couldn't come to a consensus on how to proceed. So instead of just having a back and forth for the last 20 minutes, they just left it suspended, and they'll obviously have to come back to it when they come back to it. And then for tomorrow, I've said in chat a few times, there is a committee on at 8:15 in the morning, the Heritage Committee. I've tried to cover committees that early before, but we usually only get like 40 or 50 people that tune in just because they're so early. Like on the West Coast, that's like 5 a.m. So I will clip it, though. I'm going to be up and watching it, and I'll just clip the good parts of it because the CBC CEO is in there. And anytime the CBC's in committee, it's always a pretty good con rounds. So I'll clip that. Those will be out on the channel around 9 or 10 a.m. So before we start at 11 with Ogo. And then we've got question period, and then we've got 2 committees we're going to watch in the afternoon. So I will see you guys tomorrow morning. And thanks everyone for tuning in and watching. And before I go, I did say when it happened, but thank you so much, Orc Cloud, for the super chat, and thank you, Mr. G, for the super chat. I really appreciate you guys. Everybody have a good rest of your evening, and I will see you guys tomorrow. Bye, guys.